in excess or under Article 42 of the Constitution. So, next paragraph. Learned counsel will be on the previous date of hearing, learned counsel for the respondent had submitted that the request for, we would ask for alimony, no? For alimony, we don't was born of wedlock. She's currently 14 years. So, the next having heard counsel for the parties, court is of the opinion that the agreement ratified, their marriage will be dissolved, is voluntary. So, the counsel for the petitioning husband has requested that the court may make certain appropriate observations or the interaction between him and the daughter of the respondent wife. This court is given the fact that the respondent wife has been responsible for the upbringing of her son. Nevertheless, witness of things that if in a given situation, the daughter desires to interact with the father, she should be allowed to do so.
And also, conversely, if I am going to interact with the father.
Likewise, in case the petitioner seeks to establish links with the respondent, the daughter facilitate the process. Subject to the above observations, court hereby dissolve the marriage of the parties.
Direct her to share her telephone number with me, Millards, because she is not reachable, Millards, and the number keeps changing.
One question. For 1 year, she is not giving me my daughter.
Millards, I can show from records that
1 year.
I can show from
I could order.
I'm not pressing my application.
That
I can show.
how can you have it? It's very bad to me.
It's water under the bridge, Millards, I come back.
Very bad to me.
It's gone. No, man.
See,
Communication and issue sharing a number. So likewise, the petitioner should also follow with steps to remain in touch. Periodically, remain in touch periodically, preferably once a month.
Breakthrough. Millards, may direct him to share her number with me.
Yes.
Breakthrough.
You please provide the number. Tell us.
actually, no. The order, I was telling you about.
Yes.
But
know that.
why he even went for 1 year? Or don't even. Case is
I
pending.
just want to open the case and I'll do it. Millards, that's not true, Millards.
Number, item 47.
Breakthrough.
100.
Yes, this was the matter I was mentioning. Learned AG is leading me, he's in some
What is survived because the issue of photo has now been settled.
Yes, all that we raised actually. There was one suo motu which goes against, which goes against us. The second issue is jurisdiction of NGT under section 17, whether it's
And employees compensation, etc. Why should we keep that issue open?
because this issue will have to be decided,
It will be decided until we flag that and keep it open.
What we are saying is, if my lords in the end are not convinced on the aspect of compensation to them, my lords, compensation to the dependents, but decide the issue of law. That is, my
The
lords.
question is, if it's a plain issue of this,
Yes,
we'll keep it open.
but my lords, then it could be decided now because
Why should we? I mean, this is gross case where you see we might get the other way. Why should we say that?
yes, my lords.
If this is not a normal, I mean, what
Because the issue was they were were written, my lords, there was a pocket of CO2 over there, my lords. They removed their masks while talking to each other. And therefore, they inhaled CO2 and died on the spot, my lords. Before,
Don't invite, you do not, please do not invite in order.
my lords, I'll be able to show from the record, my lords.
You may be able to show, but still we may uphold the order.
My lords,
And in law it will be, why should
my lords, that prerogative is always with my lords.
not a question
You
of
can only-
prerogative, it's ultimately what is right.
Yes, my lord. So that's in law, my lords, if we can show. My lords, in law, I can show, my lords, that section 17.
Decide it right now, please ask.
My lords, request.
So please, this has gone on, this has been, last month we did the same thing.
No, my lords, my lords, I got my
The AG has not come in
As my
the
lords,
last
then,
days.
then I will make my submission.
Yes, please.
Would my lords first kindly take up section 17 of the NGT Act?
Nationality Act.
So set it out at page 74. May I just place it for my lords' consideration? A death or for injury to any person other than a workman. So my lords, there is a clear exclusion that if death or injury is to any person other than a workman, or damage to any property or environment. My lords, in this case, damage to property or environment has not occurred. There is no such finding of the tribunal, my lords. Has resulted from an accident or the adverse impact of an activity or operation, any enactment specified in Schedule 1, the person responsible shall be liable to pay such relief or compensation for such death, injury or damage under all or any of the heads specified in Schedule as may be determined by the tribunal. Now, my lords, it's our respectful submission, my lords, that legislature has specifically included workmen and workmen has been defined, and I'll show that. The reason being, my lords, legislature already has two specific and special enactments, being the Workmen Compensation Act and the Employee State Insurance Act, my lords, which prescribe and provide for accident of death or injury from accidents to workmen. They provide for a manner in which compensation will be paid to the workmen, my lords. So in this regard, my lords, so now kindly just see section 2O of the NGT Act, my lords, which is at page 70. 70. Now, my lords, it says workmen has the meaning assigned to it in the Workmen's Compensation Act 1923. So to serve a workman, you have to go to the Workmen Compensation. Yes, ma'am.
Under the Act, the jurisdiction of the tribunal to grant damages is not structured. Is it structured or not?
My lords, it is structured, my lords, in a manner of speaking, it is structured. Yes, my lords. If my lords would first see, so broad headings are given, my lords, the national way of
Structured in the sense that like you have in the Workmen's Compensation Act or Motor Vehicle Act. You have,
my lords, in that, if that's the query, my lords, no, there's no such formula provided. It will always be based on the law, my lords. What is the loss or damage?
what is tortious?
Yes.
Tortious act.
That's right.
Therefore, there is no structure which is free to choose the method and the quantum. Right? Whereas in the Employees Provident Fund, not a Workmen's Compensation Act and the Employer Tax, which means that legislatively there is a class. If you want us to invite from that classification, we have no problem, even though it's an appeal. We will. Yes, we will.
My lords, I'll show judgment.
That we will.
My lords, I understand that.
Pressing it is not a threat because prima facie it seems that this is completely irrational.
No, my lords, I'll show that, my lords, why it will. If my lords.
Supposing that there are two
Yes.
people, one inside and one outside.
Yes, my lords.
According to the law, the one inside will get a structured compensation which would far less than what is given to us. person outside who's not a worker. Let's say somebody inside the premises who's not a workman. No, he may be an employee who's not a workman. He will get more. I hope you follow.
Yes, Manoj. May I respond, my lord?
Workman has a certain connotation. Contractors, employee may or may not be. A managerial staff will get far higher compensation. Workmen will get. We'll have to see that.
Yes, my lord. So, may I respond to that, my lord? That's a pertinent question, my lords have raised, put to me, my lords. My lords, even under tort, my lords will always go by a principle as to how that damages will be computed. Because my lords have said, even in personal injury matters, it does not mean that there will be a windfall gain. There will still have to be some aspect on which the damages are computed, which I've always taken as what was the person
Not
who has died.
We thought I doubt whether you.
Yes, my lords, that's, my lords, I'll show those line of
We
judgments.
don't have a structured law in tort. If it were, I mean, it's very important that we should, because then you can go into general damages, special damages. And, the scale can increase,
Yes,
but we don't have, we
My-
do more of an ad hoc, it's more of an ad hoc exercise in the case. Whereas in a structured one, you actually go into the income.
Yes.
Then we have also artificially, judicially imposed caps, etc.
so my lords, in tort, as my lords know now, there are some legislation which deal with tort liability, like the motor vehicle accident act.
This is also torture.
Yes, my lords, my lords, the Consumer Protection
Talking
Act.
of the general tort, there is not much structuring happening in India.
My lords, my lords are right that there is no specific on the aspect of what is the,
We have not given.
to that extent, yes, my lords. Now, my lords, my respectful submission there was, my lords, as the law stands today, my lords may develop the law. My lords, as the law stands today, even in tortious liability, my lords will always still go by the concept of by far section 73, that means putting the person back into a position that person would have been in the event that accident or injury had not occurred. That is how my lords have till now interpreted these laws. Now, my lords, if given that aspect of the matter, my lords, we in the Employees State Insurance Act also, my lords, what is seen as their wages, my lords, and that wages itself is being paid. So in my respectful submission, there won't be unreasonable classification here. I will be able to show that if my lords permit me. And my lords, insofar as tortious liability is concerned, this issue specifically arose before this honorable court in 1997, through the ESI Act, where, my lords, under the Employee State Insurance Act, the employee obtains the benefits and then.
That was where, didn't have the NGT.
Yes, my lords, not the NGT, my lords, a suit for tort, my lords. So the principle
That's
that,
probably because you have a law that stands excluded.
yes, or that's, my lords, what we are today praying, that section 17 still, my lords, the legislature still wanted to keep workmen as a separate classification. Yes, my lords, the judgment, my lords, is 1997, 7 SCC 638.
This is Ramaswamy said.
My lords, this is Justice Majumdar and Justice Kirpal, and heard by my lords, Justice Kirpal.
1997.
1997, 7 SCC 638. This is, my lords, though NGT was not there, this is on the general principle, section 50, tortious, if there's a tortious liability, whether it can.
3 SCC.
Please, my lords. So, I'm so sorry, 1997, 7 SCC 638.
From the other claims available under law.
My lords, I just placed the facts from the head note, if my lords permit, because instead of reading 2-3 paragraphs.
Yes.
My lords, while feeding the DA compound in the roller mill while pushing the same with his hands, the respondent met with an accident. However, he was allowed by the applicant company to continue in service without any reduction in remuneration. While still in service, the respondent filed an application in civil court under Order 33 Rule 1 seeking permission to file a suit. This application, although in view of Section 53 was dismissed by the trial court, was held by the full bench of the High Court to be maintainable. opposing instant appeal, the respondent contended that Section 53 should not be construed in such a way as to prevent him from about an action in tort. So that was the test query that was raised before this honorable report. Then if my lords would kindly see para 10 onwards. Para 10 and 11. And I'll place section for my lords consideration, which is referred in para 9. Para 10, if I may place 2 words. May I place para 10 minutes?
Yes.
The position with regard to the claim of an employee against his employer on his suffering an employment injury now stands set out in A. Trehan versus Associated Engineering Agencies. In that case, Trehan, who was an employee of the respondent, received injuries on his face while he was carrying out repairs of a television in the course of employment, as a result of which he lost vision in the left eye. After receiving the benefit from ESI corporation under the ESI Act, he served a notice on the respondent demanding rupees 7 lakhs as compensation. Thereafter, he filed an application under the Compensation Act claiming compensation of rupees 1,06,000. The employer objected to the maintainability of the same and relied upon Section 53 of the ESI Act. The commissioner overruled the employer's objection and followed the judgment of the full bench of the High Court in the present case and observed that ESI being a welfare legislation, Parliament could not have intended against the workmen, claiming no advantages benefits under the Workmen Compensation Act. The single advantages benefit and single judge of the High Court dismissed the writ petition filed by the employer, but an appeal held that in view of the bar created by the application for compensation filed by Trehan was not maintainable. This court analyzed the provisions of Section 53 of and observed that so and so as follows. In this context, we have to consider the effect of bar created in 3 of the ESI Act. Bar is against receiving or recovering compensation or damages under the Workmen Compensation Act or any other law for the time being enforced or otherwise in respect of an employment injury. The bar is absolute, as can be seen from the use of shall not be entitled to receive or recover, whether from the employer of the insured person or from any other person, any compensation or damages, and under the Workmen Compensation Act or any for the time being in force or otherwise. The words employed by the legislature are clear and unequivocal. When such a bar is created in clear and express terms, it would neither be permissible nor proper to infer different intention to previous history of the legislation. That would amount to bypassing the bar, defeating the object of the provision. In view of the clear language of the section, we find no justification in interpreting or construing it as not taking away the right of the workman who is an insured and an employee under the ESI Act to claim compensation under the Workmen Compensation Act. We are of the opinion that the High Court was right in holding that in view of the bar created by Section 50, the application for compensation filed by the applicant under the Workmen's Compensation Act was not maintainable. Then, my lords, I'll go straight to para 11, my lords. It is clear that the respondent could not make a claim for damages recovering otherwise. The use of expression or clearly indicate that this section is not limited to ousting the relief claimed only under any statute. The section as such that it will not be entitled to make a claim in torts, which has the force of law under the ESI Act. Even though the ESI Act is a beneficial legislation, the legislature has thought it fit to prohibit an insured compensation or damages under any other law, including torts, in cases where the injury has been sustained by employment injury.
Yes.
So, my lords, we are relying upon this to show, my lords, that as my lords rightly put to me, cautious liability.
Correct. So and even otherwise means tort.
Yes, ma'am. And therefore, my lords, NGT, my lords, the jurisdiction 10, my lords. And keeping in view that position, my lords, they have excluded workmen because Section 53 and 61 of the ESI Act specifically bars the person from getting any benefit. And NGT in this case, by granting compensation, says this will be over and above what is granted under the ESI Act. So, my lords, that's the respectful submission. Like I said, my lords,
there is I have this will it does say over and is anything higher.
No, would my lords kindly
see that last part?
Yes, my lords, kindly see page 22 immediately, my lords.
It's also very structured.
Here, my lords, they go by under the NECT Act, as my lords have given a multiplier factor. That is,
So what is the
what we are agreed by is the
previous idea?
yes, my lords. We placed that on record that they are now being paid under the ESI Act.
Now, what would the amount?
Yes, ma'am.
Incident happened.
Yes.
If they have a higher claim, point is if they have higher claims.
No, my lords, the NGT wish had said only that if my lords would kindly see page 22, around 10 lines from the top. Any payment, my lords, it also has that. After they've computed it, and after my lords, what my lords have pointed out, however, if they have a higher claim, they can go there. But please see after that also. Any payment made already towards compensation for death may be excluded from the amount which is not the ESI scheme or the monthly payments under the ESI.
That will not be excluded, that will be taken into account.
My lords, so what they are saying is that this ESI Act will be paid in addition. And my lords, what we've done is we've computed this.
Any payment already made towards compensation for death may be excluded.
That's right.
But not the employee's deposit in insurance scheme or monthly payment will not be excluded. So which means that this rate for computation of that total amount.
My lords, but then finally see how it will happen. Under the ESI period of time that the money is paid, it's not paid under the NGT direction that to pay that amount. Then my lords, that means then I stop paying the monthly amounts. It creates, if that is the issue, my lords, that the NGT is saying that this will be over and above, exclude the amount ex gratia payments that you may be making, but the ESI amount you will continue to pay. We've done a calculation, my lords, based on the life expectancy, etc., of the persons. If I may just pass on this chart, my lords, under the ESI Act.
My lord, say that over a period of 20 years or something, you pay this.
So, my lords, because this is, my lords, as my lords know, it will be paid monthly. This idea is to, my lords, see the person who was the bread earner, my lords, doesn't leave the family in penury. And this is over and above compassionate. Yes. My lords, the first one who died, my lords, Mr. Abhimanyu Saha, the NGT has calculated 30 lakhs as compensation, my lords, based on
229 lakhs, 229 rupees will remain the same throughout.
True. My lords, though,
What for the lifetime of?
she'll get around 30 lakhs 69. If she survives till 70, if she survives more, she gets more.
What is the 30 lakhs over a period of time? 229 now and 229 10 years later.
So, my lords, there, under the EA, it's not that, my lords, it will become stagnant because the fund, as my lords,
Actually examined.
my lords,
ESI, now many of them are getting just 1,000 rupees, 1,200 rupees, 1,500 rupees. And coming from a public sector undertaking.
my lords, we have to, my lords, we are on the as my lords know, my lords, we are principle of law, my lords, because as employers, we need to be aware where all our liabilities lie. And here, my lords, the NGT doesn't find that there's been any negligence. On the first date itself, my lords, we are on suo motu notice. My lords, we submit our reply. On the first date itself,
Where have you said where's your reply?
yes, my lords. My lords, my counter is at page. Page 1. And my lords, there's one more error, my lords, in my respectful submission. The National Green Tribunal says these people are not workmen under the Workmen Compensation Act. My lords, that again I will show under the definition clause itself.
They were contract employees. Question is, was this contractor
Yes.
authorized?
Yes, my lords, authorized, and my lords, I'll show from the definition itself that even contractual employees who have been taken for repair work for a pipeline will be covered under the definition of workmen.
Let's see.
Yes, my lords. Page 139 I was showing. My lords, first we mentioned the entire, my lords, how the incident took place, my lords, what were the safety protocols that we followed. My lords will see at page 143 is the safety protocols that we placed on record, my lords. And then we pointed out, my lords, step by step, what was the process that we undertook. So if I will just explain, if my lords want me to.
As Mr. Panda, what?
And last time, perhaps your lordships wanted to hear from the side workmen. There is nobody who will be repeating the workmen. I am for the state pollution control.
That's why we had moved them also.
So perhaps your lordship may appoint some amicus.
All right, we will appoint Mr. Vishwan, you appear.
Please.
Please go into the matter.
Yes. Okay.
Report counsel for the applicant. There is essentially a Workmen representative. Being suggested that Namicus is appointed representative. Keshwani is hereby requested to appoint, to appear. And this is the court as a matter.
Provided
In paperwork shall be provided for the applicant. This on after 6 weeks. Please,
I'll file this also. So, great.
But the question for the possible is on the
what is the matter?
The issue relates to payment of pensionary benefits. It's been stopped service because there is an interstate dispute in the college management and I am left in the lurch. Earlier, of course, my counterpart ought to have taken liberty while withdrawing the writ, but I would still make it good that there is a fresh cause of action. If the worker wants to hear it after a Passover,
Who is appearing for the, who appears?
I am appearing for respondent number 6. After filing of the Wakalatnama, we have no instructions from our client, so we may be treated as discharged.
That's all right. So, whom are you seeking Passover for?
For respondent 123, Mrs. Dharmadikari appears with us. He is an another for Passover matter.
Passover.
it's a 4
As an item 49.
has been instantly done. Shows the
The impugned order is because you withdrawn the.
earlier without liberty. So, but I'll make it good that there was a fresh cause of action. The subsequent prayers are almost similar. Barring one where they said I wanted a narco test earlier, so that would be an abandonment. There was a dispute among the management. So I said the current management lying, so sent him for a narco test. That was my earlier round, which was absolutely misconceived. So that of course I have abandoned. So I'm more on my pensionary benefits. Well. Okay.
I'm seeking a Passover.
49 and 40 petitioner.
Passover.
You are
For
for
responding 1 to 3, 1 and 2 are present in court. My lord, the 3 and 4 are not in India. They've not been in India for a very long time. They are not, is what my answer is.
Last time there was an order for them to deposit their
so that's all right. We want to know one thing.
The mother
We
is-
are asking them. What are the assets? You have an idea?
Yes, my lord, that is there along with the testamentary petitions. And can I just take it out?
You
In
lordship
counter
have
affidavit.
corrected them time and again.
Yes, we are aware. Please, let us also
Well,
let's understand the totality of it.
Of my counter affidavit. Running PG. I'm just pointing out, Ms. Nisha is leading in this matter since my lord has asked me, I'm just assisting.
Please.
Please, sir.
Who's in possession of what?
My lords, my understanding is the Kirti Nagar property is in the possession of the son. I am residing, I as the mother, one I'm residing in the M50 Radha Mohan. The rest of the properties are not in my possession.
This is as far as immovable properties.
Even for the movable properties, the
No, 1 minute.
yes, sir.
2, 3, 4 are immovable properties you are not in possession.
In immovable,
Sorry, 2 you are in possession.
2 are in possession.
1, 3 and 4 you are not in possession.
I'm just verified.
Hello, sir. I just want.
Just a minute, we are hearing your point.
The 2 and 3 we are in possession of, 1 and 4 we are not in possession.
1 and 4, you are in possession of 2 and 3. Then what about this Dubai property?
That's right, yes. Everything else is with the son itself, except those shares which are the subject matter of the presidency.
That is, the shares are mentioned there. Where are they?
Well, they are mentioned at page number 14, my lords, at serial number, which is the details of movable properties.
14 at number 1.
Yes. Everything in possession of the
Then
son.
No. This particular shares for which we
Please,
in passing order.
yes, my lords.
Now that is not in India.
They're not in India.
So you have to lower that, you transferred it or whatever you did.
Your Lordship, the details of the shares are at page 3, item 1.
Spiritual developers pact.
No.
It is late Shri Sudhir Kumar Oberoi had 73,80,250 shares in Mezan Holding Company.
That's what I was,
That is at their counter affidavit, page 13.
serial number 1 of the.
Serial number 1.
Right, Kuwait and United States of America. That's what I'm also. And I have done a basic evaluation of the properties that are in the
1
possession.
minute.
Yes,
Number 1, number 2 and number 3 are also in your possession.
no matters. Immovable properties only 2 and 3.
Forget more
Yes.
movable. I'm talking of movable.
For movable, only 1, which is the share in the Mezan Holding Company, for which this court is seized with the matter.
Then what about S Oberoi and?
Not with us.
You have it.
No, we don't have it.
You have it,
Yes.
sir. You have the position of shares in S Oberoi.
Your Lordship, I am not sure, I will have to take instructions on that. But after the court order, I have not transferred anything in my name. That is a statement I am making on instructions, and they have done that. Why they have done that, if your Lordship will allow me a minute, I will clear that. But
To the testamentary proceeding.
Well, it's still at the preliminary stage.
issues are yet to be framed.
Now, what is the next? What is your?
I'm filed an application for recall of 2 orders, my lords, 6th May and 3rd of February. By order of 3rd February, my lords was pleased to issue bailable warrants against me, pursuant to which I have appeared. My lords has also directed us to passports and has put an embargo on us leaving the country. With regard to that, my lords, I am very willing to give an undertaking that as and when this court calls me, I will appear.
That's not the point. The
Please.
point is, each time we require your client,
My lords, I understand. I understand I have the entire.
we will make sure that that part is complied.
My lords,
That part is complied with, we will
My lord.
do everything that you need.
please, my lords, for that,
We will not hold the order till you comply with that order.
My lords, that's why I have sought recall of both.
We will not, we will simply
Two orders,
dismiss it.
Two orders.
Simply dismiss it on the ground that you defied the court.
Not at all.
You come back with the order, all kinds of things were said, that the court there in Dubai doesn't permit, we don't know, or that company, the chartered accountant is in charge of it, etc. We don't know anything.
Please, my lords.
As far as, now it seems that you're now finding it a problem. So we will not pass any orders on this till you comply with it. And you will have, because Ms. Juneja, no, a new councillor.
Please,
So you are the latest.
I understand, my lords, I've seen the order sheet. I've seen the order sheet.
We don't know what assurance we can get from anyone, because each time the council says something,
Please.
she cannot come back, it's a court, or they release the council.
Which is why
There is no assurance for
my lords, which is why my request was that the petition respondents 1 and 2 will give their own personal undertaking before this court. First.
It is, we are not concerned with undertaking.
I will just point out.
First, some substances, tell us how to ensure that these properties secure.
Please, my lords. With regard to that, I will just point out the order of 6th of May 2023 is the 22 is when this honorable court had directed monetization and the deposit of the registry. At that stage, an impression was given to this honorable court that the respondents herein are evading service. I place an additional affidavit on record along with all my documents to show that respondent number 2, 3, and 4 were not even in the country between that entire period when the service is set to have been effective.
Once the service is done,
It was just in 2020.
whatever it is, the point is, once you are aware that this is the order, to comply with it. Decision has to happen.
My lord, what?
After that, we will grant you all the relief. You do it, till then we will not do anything. Take your instructions if you want.
My lord, then for Friday,
Why,
Friday,
you keep it, you take your own time to comply.
my lord, let's keep it for Friday. I will come back with proper instructions on all the orders and the directions given by this honorable court. Whatever legal impediments I will have, I will place those also for this honorable
You
court.
don't even know whether you will come back.
I will be there.
Your lordship may allow me 1 minute only.
Yes.
Why it is happening? Why it is happening?
Excuse me, sir. See, this boy need to call the property in Dubai. He encash it. He house 6-bedroom house. Number is 715 District 1. He took that also. And
He's your son.
My lord,
I can't say this is my son. This type of son can't.
You see, Ms. Ura, you may have your problem. We have
You know what?
difficulty in understanding that there is a problem.
He sent
Only thing is, we want you to comply with the order. Once you comply with the order, at your dictation, you have to comply with our order, then we will do what we think is right.
you please call him because
We will not call him till you comply.
and second thing, he sent the police in my home, and being a senior citizen, I didn't get up in the morning. 7 to 8 people came to my home from the police station. They are troubling me. Please stop and just tell them not to do like this. I'm an elderly lady and my legs are not working like last time also. Please help me.
She has deposited the passport.
no, my lord, with regard to
Your
that,
lordship, I don't-
the travel agent also. What had happened is the respondent, her son stayed in Switzerland. It was his birthday on the 6th, because of which she had given the passports for Sheridan visa. When after this order of this honorable court, she's asked for it back. I had that letter from the travel agent also. I can show to my lord that I had given it to the, and which is what is
Anyway,
happening.
we're keeping it on Friday.
On Friday.
You will come back and deposit if you have not deposited.
Your lordship,
May I?
one submission only. First, your lordship, the office report says, the today's report, the report from the police is that they deliberately did not deposit the passports and premise that they have given it to the travel agent. We all travel to foreign countries, original passport is never given to the travel agent. VFS service, yes, it is given, but never to a travel agent, that is one. Now, your lordship, why they are delaying? In my rejoinder, at page 3, I have highlighted how the shares of this company are and the estate is depleted. And at page 8, your lordship, I have said that last year they have taken approximately 2.8 crores of debt, about which they do not speak a line. And in another 3 months, another installment of this dividend is likely to come. They want to wait for and pocket that. In defiance of the orders of this honorable. Only two.
This is a sad state of affairs where the son is suing his mother for the properties of his father, late father. He's not even had consideration in that regard, my lord. Only that is all I'm saying. I am here.
I tried to contact on 18th of January. I met my mother. She did not respond even. It is not so. It is not that. It is not correct.
Let them comply. Please, we will tell you one thing.
Please.
Well, you are also, they are all relatives. So we will take.
My lord, mother and son. It's not even.
I don't know what is your age.
He's 37, 38, my lord.
Yeah, around 30.
38.
So if you are not satisfied, we will simply dismiss it. Okay? Now, we may at some stage require you to come and be present in the Delhi High Court because who has filed the test?
Both of us have
Both have filed.
Both have filed.
Both of you be present.
My lord.
You not should we are.
Oh यार इतना टाइम नहीं होगा. Do it.
Wait, the other one is letters of administration.
Both
Both
are
are
probate.
probate.
It's
Both
cross
are
That
probate.
is how.
Two
Yes.
ways. 5 days before the death is another will in her favor,
That's
which means we will dispute each other.
Which will show the true state of affairs, my lord, as to why the father had to reach that.
Depending on what they do, we may actually not even exist jurisdiction. We're telling you in advance. Because this is after a point of time, this is after all a contempt. A contempt you come in appeal. You can take it, we don't know. So please keep it. We will ensure that there is compliance. Thereafter, what we have to do with you, we will also take care.
Lordship, I am ready for all things.
It's not expedition, you may have to be present here in the High Court, going for some kind of mediation. This is not.
Lord, may I request if that's
Maybe you're right, they have not done this.
We will go for mediation as well. If we
Right.
decide and it is feasible, there is no problem.
Necessarily, I may file it.
You open to this additional affidavit.
May I also request if the mother can be exempted from personal appearance, the daughter will be exempted.
What is the name?
Miss Neelam Oberoi.
Is he from personal appearance for the family?
Much obliged.
To come here, I can't come.
We have all done that.
Okay, thank you. Thank you.
Much obliged.
Obliged.
In last occasion, my lord has asked if something can be worked out within the, as I actually directed the maintenance amount of per month to the wife. And the Honorable High Court has, my lordship, reversed the finding and has allowed my appeal. The wife is already having 5 acres of the land, and I have also filed the revenue report, which is also the part of the trial court. My client is the 5,000 for my lord to pay because it's not the position that she's like completely empty now. If my likeness friend agrees.
Lordship, may I submit to your Lordship? Lordship, if your Lordship will kindly see the finding recorded by the trial court. He has around 45 to 50 acres of land, your Lordship. It is a case wherein before dissolving marriage with me, he has entered. The amount of marriage trial court is 5,000 only, your Lordship. I must agree to that. But if your Lordship may kindly see the situation. In 1982, these parties got married, your Lordship. She stayed with the respondent only for 2 years. Her out of the house. He has entered into second. Since my father, till my father was alive, your Lordship, I was dependent on my father. My father died giving me 5 acres of land. That is an admitted fact, your Lordship. I must admit this. That land has been being cultivated by my hand because I am not in a position to do. It is only only after my father's death, Your Lordship, I'll file for maintenance, seeking maintenance from the respondent because there is no one to take care of the petitioner presently, Your Lordship. Regarding 5,000 rupees would be very compared with the status of respondent. Because specific finding which has given any finding contrary to this. If Your Lordship will kindly turn to page 53, this is the finding recorded by the trial court, wherein it is specifically stated, Your Lordship, that he has around 43 to 44 acres of land. Respondent. Even then,
income out of mention, my lordship, it is not a city, it's a very rural area. The total
it's an
income with the
very fertile agricultural land.
animal kind of
I think it's harvested in the neck.
Yes,
yeah, so it is 7 lakhs a year. It is 7 lakhs a year, my lordship, the
1800 quintals of paddy.
lakhs.
1800 quintals of paddy is harvested
And
in 40 acres of land.
see the other aspect, there was an agreement, and if my lord would see at page number 21 of the what section 125 clause 4 says that if the party mutually decided to the part the spouse cannot pay maintenance if the parties decided to must be separately. In fact, there is a 2 High Court judgment which also says that an agreement, if by way of an agreement the parties decided to live separately, then the wife cannot. Although there is no Supreme Court point, but if my lord would want,
There is a Supreme Court decision to that.
2 High Court judgment with me, my lordship. The other aspect is that, my lordship, after 14 years they have entered into the agreement that they will live separately and that they will not file any.
When did you get married?
1982.
No, it's married.
2000
Marriage, I don't have the date, my lordship.
Your Lordship, it's recorded the trial compromise agreement was executed trial court. Yes, sir.
The multi parties live in the village and they receive category 1.
Page 43, top
Page number 43.
Start, Your Lordship, water. It is non-applicant head notice year 2002. Therefore, applicant has the fact of second marriage in the notice exhibit giver issued to the non-applicant. On this basis, this is statement of non-applicant that non-applicant solemnized second marriage is of dated 24/3/2003 does not appear to be true. This is the finding, clear finding of the trial court, Your Lordship. Then, at para 29, the court recorded a finding that the or merely with the consent of the party, there has to be a decree of the civil code, because the respondent has not given any evidence to show that in the Patel community there is a custom that the marriage can be incest.
It is oral evidence for a trial.
It was on the date in contention of the petitioner is when it was executed. It was assured to the petitioner that
In the 1980s.
No, 2000. Very oral by of the assumption which the
Workshop Shukla, there are two. One is obvious, we will not interfere. The other is we will go into the merits and restore the trial court. Then all your contentions are there. She can get maintenance from you.
Well, actually, obviously, I completely covered in a lot, my lord. But there is
Actually, exhibit D2 is there.
Your Lordship, it is not on record. It is not covered.
You must be having a paper book.
Your Lordship, it is reproduced in the tuned order, Your Lordship.
Only
Only the part.
the order of the manager which is under challenge is agreement.
Malashi, in the counter affidavit at page number 11 is the agreement in English, madam.
Page number 11 in the.
Yeah, it is the piece. I mean, it is the same agreement which is reproduced in the in page 4 of the High Court order.
Page 11, no?
that no party will have any claim against each other. It is Malashri one-time permanent alimony. And Malashri, as per section 125 clause 4, the parties mutually have agreed to. Therefore, there is an embargo of 120.
It's against you that you got married prior to this. That finding has not been completed or even set aside.
In Your Lordship, there is a judgment of the Honorable Court which says that such a compromise will not prevent the wife from 2014, Your Lordship.
That's the only thing we can do. We will set aside the High Court judgment.
I propose 1,000 rupees a month.
You come out with a better offer.
I will, my lordship, because you know, my lord.
Otherwise, one has other ideas also.
In fact, my lordship, on the aspect of land also, we have to discuss it because
We discuss it. Otherwise, I have other ideas about the land. I will not.
I will, even if my lord also come up with a fix.
Your Lordship, on the last date of hearing, ask me, Your Lordship, I took an instruction. I'll take a lump sum amount down